So, amid the fierce competition of the politicians who want to contest the off-season governorship election in Bayelsa State in November, yet another improbable plotline has been added to the mix. With the pre-election political show heating up there and a motley of hopefuls all trying to convince the people that they have a lot to offer, the ambition of one of the frontline candidates, Sylva, the immediate past Minister of State for Petroleum Resources, has hit the buffers, with the Federal High Court in Abuja disqualifying him from taking part in the race because, according to the court, he's already taken the oath of office twice, and being allowed to contest again would violate the provisions of the 1999 Constitution. So the APC in Bayelsa State clearly taking in and coming to terms with the full weight of what has happened to their ambition to wrest control of the state from the PDP. So where do things go from here? Well, for his reaction to this court judgment, I'm joined now on the line from Bayelsa State by the chairman of the APC in Bayelsa State, Barrister Dennis Otiotio. Thank you very much indeed, Barrister Otiotio, for joining us. So a bit of a rupture for you and your aspirations of your party to govern Bayelsa State with this disqualification of your candidate there, Sylva. What's your reaction to that?
Well, thank you very much for giving me this opportunity. You see, we received the judgment that was given around 7:38 in the evening yesterday with mixed feelings, because we know that case, the plaintiff in that case does not have the locus to present that case before the Federal High Court. We are all aware, even those who are not lawyers are aware, that the current Electoral Act 2022 circumscribe or limits the category of persons that can take a pre-election to court. And Section 29, subsection 5, and Section 8 only two provisions under which a litigant can take a candidate or go to the Federal High Court for a pre-election matter. And the Supreme Court, in several cases, more than 30 of them, in last year and this year, pronounced that only an aspirant who participated in the primaries of his political party to bring a pre-election matter to the Federal High Court. And so the plaintiff in this matter, Chief Kolomo, was neither an aspirant or a participant in the primary election that was conducted to select the governorship candidate of APC in Bayelsa State. And so it is very clear that he does not have the locus. And where the plaintiff does not have a locus, the court itself does not have the jurisdiction to entertain that matter. Apart from that, secondly, the court lacks the local, the plaintiff in the matter lacks the local standard to institute this case, because he was not an aspirant in the primary election that was conducted to select the governorship candidate of APC in Bayelsa State. And the Supreme Court...
Right. I think he's talking to me from Bayelsa State. I don't know whether there's probably weather problems back there, but you seem to be back again. We're sort of going in and out with you. But let me ask you this. I mean, you've made the case about the jurisdiction of the court and the locus standi of the person the plaintiff. I mean, From where I sit, though, and just listening to a few legal analysts, I mean, it seems fairly straightforward. I mean, the judge ruled that Mr. Sylva, having been sworn in twice and having governed the state for 5 years, would breach the 1999 Constitution if allowed to contest again. I mean, that seems like a clear interpretation of the Constitution. I wonder if you can hear me, because you're talking about what people would argue would be little technicalities, but the main thrust of the court's decision appears to be an interpretation of the Constitution.
Are you hearing me? Before a court can assume jurisdiction to begin to interpret the Constitution, it must have the proper parties before it. And the case must be within the statutory district. What we're saying is that, one, that there is no locus. Two, the case itself is statute barred because the name of the governorship candidate of Imo, Bayelsa, and Kogi were published on the 12th of May 2023, while this case was filed on the 13th of June 2023, more than 1 month after the names were published. But Section 2859 of the Constitution is very clear that a party who is aggrieved must file a pre-election matter within 14 days of the occurrence of the event or decision complained of. Now, the name of Chief Timothy Sylva was published on the by INEC, and he waited till over 30 days before he went to the High Court to institute an action on the 13th of June. And so, before you talk about, this is not technicality, this is the constitutional provision. Before the court, the Federal High Court can assume jurisdiction to entertain this matter. What we're saying is that the court lacks jurisdiction to entertain the matter. But even on the merit of the substantive matter, look, with due respect to the judgment of the Federal High Court, I will beg to differ to say that look, this matter was instituted when Goodluck was contesting for president in 2015. And this is what the Court of Appeal said. The Court of Appeal said, look, that section where it says the person must have not been elected to that office in 2 previous occasions means that the election that is contemplated in that section is an election that had gone through the full process of election, which is purchase of nomination forms, party primaries, conduct of publication of submission of name to INEC, publication of name by INEC, conduct of election, declaration of result, and issuance of a certificate of return. It has to follow through the entire process from the beginning to the end. That is what the Constitution, section 182, subsection 1b, contemplates that the person has not been elected into that office in 2 previous occasions. So, in this case, Sylva was elected into office in 2007, and then the appeal court, which was the highest court of the land with respect to governorship tribunal matters, ruled in Angbari versus Sylva that there was no election in Bayelsa State and ordered INEC to conduct a fresh election. Now, the fresh election that was conducted in 2008 did not envisage new people into it. It was just a continuation. It was as if in 2007, April, when the election was conducted, there was no election, the time was paused, and then continued on 2008. And so, no judge or no lawyer will want to interpret that these are 2 previous elections, because they amount to just 1 election, because the previous election was nullified. The judgment of the Court of Appeal in Angbari and Sylva is very clear that the first election that Sylva contested was a nullity, and it was declared void. And so, it was a subsequent election that counts. And so, if somebody comes to say, oh, because he has contested election in 2007, which was nullified by the court, and the second one that he had been elected to that office in 2 previous occasions. So, are we now saying that Sylva is has been governor of Bayelsa State twice? No. Now, the second issue that was raised was that, that if Sylva wins election, that he is going to have stayed for more than 8 years. And then they not. So, but you see, courts do not involve themselves in speculation. Courts do not involve, is not concerned with the business of speculation. Because if you say, if Sylva wins, Sylva has not won. Sylva is contesting the election. So, courts are concerned with life issues, issues that are present before them. But the issue as to whether, if Sylva wins, whether he's going to stay for more than 8 years, has not ripened now, because he has not won the election. It is when he wins the election that somebody can take him to court to say, look, you have been in office for 5 years, and so if you stay for another 4 years, you are going to be you are going to stay for more than 8 years, which is not within the contemplation of the Constitution.
Well, with all due respect, Barrister Otiotio, you've gone from talking about this as a pre-election matter and now talking about it as a post-election matter. You may well be making a lot of sense, but it'll confuse people who are listening and watching. And I just want to bring us back to the main issue, what the plaintiff. Let me just make the point, and I'll come back to you in a minute. The plaintiff wanted constitutional clarification that, having regard to the indisputable facts that Mr. Sylva occupied the office of Governor of Bayelsa from May the 29th, 2007 to April 15th, 2008, and again from May the 27th, 2008 to January 27, 2012, whether he is qualified to contest and be elected to the office of Governor of Bayelsa State for another 4-year term in view of Section 180 subsection 2A of the 1999 Constitution. And the court agreed that he competed in 2 elections. And you're saying that that constitutional interpretation is wrong. I just need to be clear on the points that you're making and what grounds you're now going to presumably launch your appeal.
Now, you see, that's what we're saying. First, that's what we're saying. They came under Section 182A and Section 182(1)B. In Section 182(1)B, it says the person must have not occupied the office in 2 previous occasions. And they are saying Sylva had occupied the office of governor in 2 previous occasions. And we are saying that, look, that cannot be correct interpretation of the law, because the first time Sylva was elected in 2007, that election was nullified. It was declared null and void. He vacated his office. The Speaker of the House of Assembly was mandated to act as acting governor, wherein he contested again. For instance, assuming he lost the second election, will you say he was governor of Bayelsa State? No. For instance, in Rivers State, Celestin Omeya was elected as governor of Rivers State. But unfortunately, the Supreme Court nullified his election and said he was not the candidate of that election. That was Rotimi Amechi was the candidate of that election. And Rotimi Amechi was sworn in as governor. Are you going to say that Celestin Omeya was governor of Rivers State? No. That is not correct. It cannot be a correct interpretation. Secondly, when you say under 182A that a person is required to, that if he is elected governor this time, he will spend more than 80 years in office. These are the issues that were before the court. And I'm saying that, look, that issue is not ripe for determination now. Because you say, if he is elected, if itself is speculative. Because he has not been elected. And so, if he has not been elected, there is no ripe issue before the court to determine. And look, appeal is principally going to be based on the fact that the court lacks the jurisdiction to even entertain the matter, because it is a pre-election matter. And the Supreme Court had given plethora of authorities, decisions, last year and this year, to the effect that only an aspirant who contested the primary election of a political party that can take a matter to court on pre-election matters. Because pre-election matters are sui generis.
Right.
You must come, you must show the court authority, the law that gives you the locus to come before the court.
Okay.
You can't just it is not an all-comer affair.
Well,
anybody cannot just come from the street and say, look, that is what this plaintiff is doing.
No, I understand the point you're making, but let me just come in there, Barrister Otiotio, because the judge said also that the Supreme Court had already set a number of precedents in rulings in which it clearly stated that no one can expand the Constitution or its scope. In other words, if Mr. Sylva is allowed to contest the next election, that would mean that a person would contest as many times as he or she wants. But anyway, it's not for me to argue the case.
No,
I mean, we're not in a court of law. What I want to ask you now, because we've got just about a minute or so left, what happens next? Are you going to appeal?
Good. Now, let me tell you, in Adamawa State, Yanko was removed like Sylva. In 2000 and Yanko contested. Yanko contested the election, won, and stayed for under 4 years. Not only in Bayelsa, even in Cross River State and other states. It's not peculiar to Bayelsa State. And so if the judge says it's a new precedent, it's not a new precedent. In Adamawa State, Yanko stayed for another 4 years. After there were 5 governors that were removed. It was only Sylva that was not allowed to come back. All the other 4 governors were given a second term. Well, the last question you asked, we have already instructed our lawyers to appeal. They are in the process. I think they have already filed the notice of appeal. They have filed their notice of appeal. We have also filed the motion for stay of execution of that judgment pending the determination of the appeal by the Court of Appeal.
I want to thank you very much indeed.
And so we are calling on all our supporters to be calm, because we believe that this judgment will not stand the test of judicial scrutiny. We believe that the appellate court, going by the precedent that has been set by several decisions of the Court of Supreme Court, we know that this judgment will be set aside. Because we know and we believe that
I'm very
it did not
concerned.
represent the true state of the law.
I'm very concerned with your line. Your line is kind of a bit wobbly there, but I really appreciate the time you've taken to try and explain this to us, and obviously we'll follow the case as it goes through appeal. Barrister Dennis Otiotio is the chairman of the APC in Bayelsa State, and he was talking to me from there.